So thanks everyone for signing up, and for attending this DBCS and PitchMark webinar. My name is Cheryl Marie Tay, and I'm the editorial director for PitchMark. So just to give you a bit of an introduction to PitchMark, we basically offer a service where we help to protect the ideas of innovators and creatives before they pitch it to potential clients to help to deter idea theft. So, as of now, registration as as a PitchMark member is actually free of charge to all innovators and creatives, and our services are free of charge as well. So, to give you an idea of what we help you to do, when you share with us the files that you want to protect, we actually generate a certificate with a unique serial number as well as a timestamp and a date stamp to prove that these are your files and these are your ideas. And we also give you permission to use our logo on all your relevant materials, as a sort of proof that these are your original ideas. And in case anything happens to them, in case anyone uses them without your permission, you at least have some proof that these were your materials in the first place. So that's what we're trying to help people do. And we're trying to give a platform to innovators and creatives as well to share their own stories and perspectives when it comes to intellectual property and the issues that they face with it. So this is in essence what PitchMark does. And so, we are very happy to be partnering with the Design Business Chamber of Singapore for this particular webinar. And yeah, thank you very much. Sangeeta, is there anything you would like to add before we carry on?
You can go to the pitchmark.net website and learn more about registration. We don't believe a service like this exists anywhere in the region, if not, well, I wouldn't say the world right now, but we're working towards that. We're working towards making this a very unique service. It is a Singapore-based service, so please support local and register. It's like a vault for your creative assets that you can use, a secure vault through which you can also send your files to your clients, and your clients are sort of notified of the consequences if they use it in the way it's not supposed to be. So obviously Frank would can tell you a bit more about that and other options that can exist, but I will let Sue Ann take over now and tell us about DBCS.
Sure, thanks Sangeeta, and thanks everyone for joining us and giving us your time on this Friday afternoon. So I'm Sue Ann. I'm part of the ExCo of DBCS, Design Business Chamber Singapore. And so DBCS is actually a multidisciplinary chamber, and we look to facilitate collaboration between the design and business communities. So in recent years, we have incorporated the tagline, which is better business by design, because we see it as extremely important and really our manifesto in advocating the application of design thinking in business, and something that I think is also something very relevant to all of you here and something very important as well. And finally, just want to share a little bit about our mission. Yeah, so hopefully this diagram kind of neatly encapsulates our vision, which is really looking at design in practice, and also the business side of things, and finding that intersection where we can achieve better business by design, but also to find that kind of cross kind of intersection where we can also then use design for social good. So again, thanks for joining. I hope that everyone is able to take away something from today, and very happy to be collaborating with PitchMark as well. Back to you, Sangeeta.
Okay. As as the slide here shows, we have Frank, our legal advisor, who has worked in the US in creative agencies, has worked across Asia in Singapore, Hong Kong, and Bangkok, and has had to do with regulators controlling or who are setting policy about IP issues all over the region. So Frank knows a lot about IP and its use and misuse in Asia and elsewhere. So this is just some of the key topics that will be covered as part of the webinar, the types of IP. Perhaps some of you have already, gone through this as part of your design studies, but Frank will, be giving you a bit more of an sort of overview from the real world. And clearly, as we say in, at the end of the presentation, you'll be able to ask him your questions, which, as a designer, I think, or people in the media and creative space, almost everyone has an IP theft or infringement story to share. So here's your chance to ask him your questions, put them into the chat. Frank, are you ready to go?
Yeah, hi. Thanks for that introduction, ladies, and thanks to the Chamber for the kind invitation to join you guys today. Good afternoon, everybody. I'm Frank, and I'm a legal advisor for PitchMark. And as Cheryl mentioned, PitchMark's a new tool that'll help creators and lawyers promote and protect intellectual property by evidencing its source of origin and tracking and tracing its subsequent exchange. And we'll get back to PitchMark again and its relevance to the creative industries towards the end of the discussion. Yeah, just by way of background, Sangeeta mentioned I'm an entertainment lawyer. I'm originally from New York City, but I've been living in Asia for most of the past 24 years, including Singapore, where we raised our children, and then Hong Kong and now Bangkok. I started out in the book publishing industry, negotiating rights acquisition and licensing agreements for Macmillan. And then I spent 12 years with the National Music Publishers Association and the Harry Fox Agency, and that's what got me over to Singapore. And then I spent 14 years with the Motion Picture Association's regional office in Singapore, and during which time I worked closely with the 6 major Hollywood studios. Right now I'm with the Motion Picture Licensing Company, and we do public performance rights licensing for film and television producers. And what I want to do to give you today is a very brief primer on intellectual property protection, what it means, why it matters, and to focus in some detail on protection for designs. Now, that said, this is the first time I've ever given a presentation on design protection, so I'm going to thank you all in advance for indulging me and apologize up front for anything I don't know. In fact, I'm kind of filling in for another PitchMark counsel who wasn't able to join us today because of a scheduling conflict. But our plan is to do more of these sorts of events in Singapore over the next few months, so do keep an eye on us and get on our mailing list for future announcements. So with that, let's begin. Sangeeta, could you, I guess, you'd advance the slides, please? Okay, so intellectual property, it's a general term that encompasses several different forms of creativity. And they're all slightly different unto themselves, but you can maybe think of them as separate fingers from a common hand. And maybe a helpful way to think of intellectual property might be as products of your mind or your intellect, things that are new and innovative, things that convey expression, or a consistency of origin or consumer expectation. Now, these are things like inventions or artistic or literary works or designs or names or symbols or images that are used in commerce. And the protection extended by intellectual property is to allow people to earn recognition or a financial benefit from what they think of or create. But as we'll see, the rights aren't necessarily all encompassing or permanent or indelible. And they're instead mostly subject to limitations that are intended to strike a balance between creators and the general public. The idea is that we reward creators for their creations, there will be more creations that are put out there in the marketplace, which will in turn benefit the wider public interest. And it's considered that we as a society are better off by having more thoughts and ideas out there competing for our attention and our money. So we try to create an environment that will be conducive to innovation. So let's take a look at some of these in no particular order of importance, starting with patents. Now, patents are exclusive rights that are extended to inventions, and patents allow patent owners to decide how or whether the invention can be used by other people. And in exchange for this right, the patent owner makes technical information about the invention publicly available in the published patent document. And in Singapore, patents are protected under Chapter 221 of Singapore statutes. A trademark, on the other hand, is something, it's generally a sign, that distinguishes the goods of one enterprise from those of another. So for example, if you want a Big Mac, you take yourself to McDonald's. If you want a Whopper, you have to go to Burger King. And the reason you, as a consumer, think of and remember either of those products is because of their consistency and their predictability, no matter where you are in the world. Now, in Singapore, trademarks are protected under Chapter 332 of the statutes. Now, next up is copyright, and that's the term that's used to describe the rights that creators have over their literary or their artistic works. Things like books or plays or music and recordings, paintings, sculptures, movies, maps. Copyright extends limited protections to creators for the expression of ideas for a period of time, following which the expression falls into the public domain. And in Singapore, the Copyright Act can be found in Chapter 63 of the statutes. Now, geographical indications, they signify sources or places of origin that involve unique characteristics or traits that are specific to goods coming from that place, and which distinguish those goods from similar products from other places. So for example, champagne, that's an appellation that's specific to sparkling wine that's produced in a particular Provence and valley in France, utilizing a certain method of preparation. And geographic indications are protected in Singapore under Chapter 117B of the codified statutes. Now, another type of IP protection would extend to trade secrets, and those really have to do with confidential information that can be sold or licensed. And the unauthorized acquisition or the use or the disclosure of this information in a dishonest or an unauthorized manner is considered an unfair business practice. Now, interestingly, there isn't a specific law in Singapore going to trade secrets as such. It's protected under the Unfair Competition Act. But moving on, just to illustrate more, yet another type of IP protection available is for integrated circuitry layouts, or so-called mask geometry that refers to three-dimensional character of the elements and interconnections of an integrated circuit. And these are protected in Singapore under the eponymous Layout Designs of Integrated Circuits Acts, or Chapter 159A of the statutes. And finally, but not exhaustively, we have industrial designs, which constitute the ornamental or the aesthetic aspect of an article. Now, as you all know, a design can consist of a three-dimensional feature, such as its shape or the surface of an article, or its two-dimensional features, such as its patterns or lines or representations of colors. And there's a separate IP law in Singapore for designs, and it's called the Registered Designs Act, or Section 266 of Singapore statutes. Now, the thing is, these laws are all mutually exclusive, but your creations aren't necessarily. And it's true that they can overlap, there can be some overlap of protections in certain instances, say between the Trademark Act and the Geographic Origin Act, or between certain provisions of the Copyright Act and the Registered Design Act. I mean, a design can be protected by copyright to a degree, but not past a certain point, depending on what you want to do with it commercially. And a consumer product can be protected by both copyright and trademark due to the particular characteristics that are associated with it. I don't mean to get too technical or confusing. I'm just trying to illustrate these are all really kind of different fingers of a glove, if you will. Each one is supposed to have a different purpose and reason behind it, but you know, they all kind of work together in their own way to maximize the functionality or the protection of the hand. And you know, I'm sorry, that's probably a very bad mixed metaphor or an inappropriate analogy. It just means that, you know, your thumb is different from your ring finger, even though both are in the same general category of body parts that serve the same functional purpose. I better move on. Next slide, please. Sorry. Now, one thing that all those protections have in common, though, one thing that all laws have in common, is that they're limited by their scope and their application to the territories in which they're created. So the IP protection that's available to you in Singapore is what the Parliament has enacted by virtue of the legislative process in Singapore, no more no less. And then after the laws are enacted by the legislature, they're typically entrusted to the government to be overseen and administered by the executive branch. And in this case, that would be the Intellectual Property Office of Singapore and the Ministry of Law. And of course, laws are always subject to the interpretation and the further oversight of the judiciary. And the point I'm trying to make is that the laws in Singapore only apply in Singapore, at least most of the time. You don't get to fold the laws up into your pocket and take them with you wherever you go in the world. There's no universally recognized IP rights that exist inherently or extend uncontrollably throughout the cosmos like air. And of course, the laws around the world vary from country to country. And what's legal or permissible in one jurisdiction might not be in another. So what there are instead are international treaties. And that's where sovereign governments all get together and they voluntarily agree that they'll all go back home and make sure that their laws measure up to whatever minimum standards they've agreed to during the treaty negotiations. So, when Singapore sends its representatives to the World Intellectual Property Organization, for example, to negotiate an international treaty on design registration, they and all the other members agree that, at the end of the process, the laws in each of their countries will, at a minimum, measure up to the treaty levels of protection. Like we all agree that we'll go home and our registered design acts will provide as follows, ... So these treaties are not international laws per se. They are instead frameworks for reciprocity among sovereign governments. Treaties are enacted by representatives of national governments, but they're typically administered by multilateral organizations. As I mentioned, the WIPO a minute ago, or the World Trade Organization is another one. International treaties are not typically self-executing. At best, they represent a commitment in good faith that they'll be ratified or acknowledged back home within each country's legislative framework. But the reason that countries negotiate treaties are because of the priority benefits that they provide, which allow creators from Singapore, for example, to receive the same degree of design protection in Germany that German designers receive under German law and vice versa. And I'll illustrate that concept shortly, but you can think of it like as joining the Tangling Club and getting the benefit of reciprocal membership privileges at their sister club in Zurich or what have you. You still have to play by the rules of whatever club once you're there, but you automatically get to do over there what all the other members over there get to do. And this all helps to ensure levels of consistent protection around the world, and that also helps creators to monetize or exploit their IP in the global marketplace. Next slide, please. Now, I mentioned that in Singapore, there's a law called the Registered Design Act, and it's Chapter 266 of the Singapore Statutes. And according to that law, if you come up with a design and you register it for protection, you get an exclusive right of ownership for it and the right to prevent others from using it without your permission. And by protecting your design, you can also therefore promote your design. Because once you can stop other people from using it, you can also license its use to other people for a fee, or you can sell it altogether. Now, the primary requirement for registering a design is that it be new, meaning that it not be previously registered in Singapore or elsewhere. And not every design is eligible for registration. For example, designs that are considered by the examiner to be contrary to the public order or morality are not eligible for registration. Computer programs, for example, are not eligible for registration, nor are designs that are applied to certain articles such as wall plaques or metals or printed matter. Methods or principles of construction are not eligible for design registration, nor are designs that are dictated solely by function. And finally, so-called must-match and or must-fit designs that are essential to functionality are not eligible for registration. Now, sorry, lost my place for a second. Yeah, so there's no protection for colors per se. They did a review a while ago in Singapore, but they came out with a revision that said you can combine colors with certain degree aspects of their functionality that would render protection across to it. And, you know, article means anything that's manufactured by hand or an industrial process or otherwise. And a non-physical product refers to something that's produced by projection of a design onto the surface or onto a medium. Can we go to the next slide? Okay. So I mentioned that, you know, I started by saying that not every design is eligible for registration, but when you do go to register your design, you have to specify what type of goods that it's going to relate to, whether it's going to be for a piece of furniture or for jewelry or for a musical instrument or what have you. So how do you figure that out? Well, you remember earlier we were talking about international treaties. Back in 1968, they got together in Locarno, Switzerland, and they negotiated something called the Locarno Agreement. And that's a goods classification system of 32 different categories of products for which designs could be registered. And by now there's something like 60 countries around the world that have signed on to the Locarno Agreement, so that the classification numbers for registration purposes are the same in each one of these countries. And you know, there's a similar system of classification in place for trademarks called the Nice Agreement. Anyway, when you apply your design for registration, you need to indicate which particular classification or classifications of product are to be associated with it. And you can always register the same design for more than one product category, but governments will typically impose a separate registration fee for each category for which you register. And if the registration application is approved, you get those rights of protection that I mentioned for an initial period of 5 years. And you can renew that registration period 2 more times for a total duration of 15 years protection. Now, typically, the designer is the owner of rights afforded by the registration, but there's an exception to that general rule if designing is a function of your employment, or if there's a contract in place whereby you've agreed to vest or transfer ownership over to somebody else. But specifically, registration gives you in Singapore the exclusive right to make in Singapore or import into Singapore for the purpose of sale or hire or use in trade or business any article or device that is, quote, not substantially different, close quote, from the registered design. Now, admittedly, that's not terribly clear in practice, but that's what the statute says, and you know, that's what lawsuits are all about. But should someone infringe upon your registered design, you can bring a civil action against them, seeking an injunction to stop them from any further use of your design, or seeking profits that they made by virtue of infringing your design, or recover any losses or damages that you suffered because of the infringement. But you know, you can't put someone in jail if they rip off your design, because it doesn't rise to the level of a criminal offense in Singapore. Now, interestingly, however, if you, the designer, falsely represent to your client or to the public that your design is registered when in fact it isn't, guess what? That's a criminal offense. You can go to jail for that. Now, when you go to register a design in Singapore, you start by doing an online search to see if it's already been registered by somebody else. And you do this on a website that's run by IPOS, and I should have put it down on the slide, but it's IP2SG, ip2sg.ipos.gov.sg. And if it hasn't already been registered, you can complete an application online and you submit it along with what's called the statement of novelty. And that's basically a drop-down menu in a pre-completed template online. And at least one representation of the design. And the registration fee is 250 Sing dollars per classification. And there's an estimated 4-month turnaround time, during which the examiner, who is an IPOS staff representative, will review it for acceptability. Remember, I mentioned before what's eligible and not for registration. And there are other formalities that go on behind the scenes, but if the registration is approved, it next gets published in the Designs Journal and on IPOS's website. Now, for reasons that you guys will understand, it is possible, excuse me, to request as part of your application that the publication of the design, once it's been accepted for registration, be postponed for a period of time. And this is because the design has to be compared to designs that were published earlier. So if you were to disclose a design to the public, say at a fashion show, you run the risk of invalidating your own registration, because by the time you go to register it, you already published it and it isn't new anymore. So what they do in Singapore is they offer a grace period of time during which you can test the design around in the marketplace before you make the decision to register it. Now, remember when I said earlier that laws vary in their specifics from place to place? Well, it used to be in Singapore that they gave you a grace period of up to 6 months, but only when the first disclosure occurred at a select list of international exhibitions. They changed that a couple of years ago, and now the grace period extends for up to 12 months from the date of first disclosure, and they removed the requirement that disclosures could only be made at select international exhibitions. So, long explanation, this is one way to go about registering your designs for protection in Singapore. Dozens of countries around the world operate similar registration systems. So at that level, if you want to protect your design in, say, 25 different markets around the world, you have to submit at least 25 different sets of applications, often in different languages and at different prices, payable in different currencies. Can we move on to the next slide, please? But there is another way, and that's by virtue of something called the Hague System. And the Hague System is another child of international treaty negotiation. It's a system that's similar to the one in Singapore run by IPOS, only this one is operated in Geneva, Switzerland by the World Intellectual Property Office. Now, under this system, you submit one application in one language for one price, but the registration then applies in 91 different jurisdictions around the world. And the basic mechanics of the Hague system are pretty similar to those in Singapore in terms of what's acceptable and what's not, and what the procedure is. The website resource that you go to start the process is called the Hague Express. And the Hague system recognizes and utilizes those same Locarno classifications for products and devices. And you get the same initial 5-year term of protection. And as in Singapore, you can renew the registration twice more for a total of 15 years worth of protection. And, you know, like in Singapore, you start the process by going online to that portal to check the availability, and then you submit an application along with a representation of the design. And now the cost here is 425 Swiss francs versus 254 Sing dollars. And the turnaround time, if all goes smoothly, is approximately 6 months from the date of submission. So now, you know, which approach is better? I think the answer to that really would depend on your particular situational needs and your circumstances. And now, obviously, there are professionals out there who will happily undertake all of this stuff for you as a service provider for an additional fee. And those people can also advise you, you know, based on your specifics. But the point I'm trying to make is you can do all of this stuff yourself. Can we go to the next slide? Because there are a number of resources that are out there to help designers.
Sorry. Let me go back.
Some better work. Can we go back to that one? Yeah. Let's wrap this up quickly. A bunch of resources are available to you. So in Singapore, a really good resource source of information would be IPOS. And I mentioned before that among other things, they administer and maintain the IP2SG website portal. And they also run various workshops and seminars and training opportunities, their IP Academy resource. And they also make available designs info pack with additional information and a steer towards other resources. And I mentioned WIPO. They're located in Geneva, Switzerland. They're in fact a branch of the United Nations, which is another really good resource of services and information. And WIPO administers both the Hague System and the Hague Express portal and the Global Design Database. And they administer the Locarno classification system that I've mentioned a few times. And they also have various committees that meet to get together annually to discuss design topics. And I should mention that the current Director General of WIPO, as of last October 1st, is Mr. Darren Tang, who was previously the Chief Executive Officer at IPOS. But finally, I just want to talk for 2 minutes about PitchMark, what it offers as a resource for designers in Singapore and around the world. Now, Cheryl mentioned PitchMark is a tool that's available to creators and innovators completely free of charge, and it provides instant ownership certification that can be attached, if you will, to any intellectual property that you create and that you subsequently distribute to other people. And you can almost think of it as like a unique fingerprint or maybe a tattoo that becomes associated with your particular creation, or you can maybe think of it as an unobtrusive sticker that's attached to that creation as part of its packaging. You and only you can remove the PitchMark if and when you choose to. For example, if you submit a design proposal to a particular client who loves it and then wants to pay you to use it. Now, PitchMark utilizes so-called personalized blockchain technology to then track or trace the subsequent distribution or exchange of a PitchMark creation wherever it goes digitally thereafter. So let's say you're asked to submit a design proposal to a client for, I don't know, a wall clock. What you do after completing the design, but before you submit it to the client, is that you PitchMark it. So you go to the PitchMark website, which is pitchmark.net, as a registered creator or an innovator, and you upload the file by means of a drag and drop interface that generates unique and specific PitchMark identifier. That identifier will take the form of a digital certificate or a token, which is then attached or digitally affixed to the file. And when you submit your proposal and the receiver goes to open it, they'll be notified that what's being submitted to them is protected by PitchMark. And it places them on notice that you have certain intentions and expectations for it. You know, the main one being that they shouldn't try to take it and run away and rip you off by using it without your knowledge or your permission. You know, PitchMark is not a magical silver bullet solution to prevent any of that from happening. You know, it's instead a resource for creators, an arrow in your quiver, if you will, that should help build awareness about intellectual property rights and acceptable behavior. And so finally, you know, in that respect, you can think of PitchMark as a sort of community that we're trying to build, a community of a grouping, if you will, of like-minded thinkers who, by seeing the PitchMark sign, know and understand what it means, which is basically, you know, what our parents all taught us, which is you don't take what doesn't belong to you. Next slide, please. Which is where I shut up, and I hope I didn't throw too much at you guys and gals, and I hope at the same time, you know, you know a little bit more about IP protection now than you did before. I know I probably ran over my time, but if there's any left, I'd be happy to try and address any questions or clear up anything that I might have muddied up.
Thank you so much, Frank. That was a masterclass in IP in 20 minutes, which I think we're all fortunate to have. I'd just like to start off the Q&A session, and then Cheryl will be reading out questions which have been put into the chat. I have a big question that I guess lots of people are interested in, a significant question, let's put it this way. You mentioned 91 countries where things are registered. There's obviously, 180 or 200 countries now at this point, I think, around the world. Where does China fit into all of this?
Oh, China's fascinating. I mean, they've really changed their attitude on IP, and they're taking every step they can to try to beat players in the world circle. There was a big treaty that was negotiated on behalf of performers' rights in Beijing about almost 10 years ago. But to answer your question, Sangeeta, on the WIPO website, you can see on any international treaty who the signatory parties are. They change, obviously, from time to time, but I do believe that China is part of the Locarno Agreement and part of the Hague System. They're definitely world players on the intellectual property scene by now.
Now I'm opening the floor to questions.
Yeah, so thank you very much, Frank, for the presentation. We do have one question from one of our attendees, Ryan. He says, as creators, we are commonly told that it's one thing to protect our IP, but another thing to enforce it, and that most SMEs are usually not fully equipped with the right resources to enforce or defend their IP when they really need to. So if this is true, what are our options?
I'm sorry, Cheryl, you're not coming through very clearly loud to me. I think the question had to do with the basic difference between protection and enforcement. And as a practical matter,
yes, and it also mentions that SMEs are not usually fully equipped with the right resources to enforce or defend their IP. So in this case, what are the options?
yeah, certain, sometimes IP infringement can rise to the level of a criminal offense, and police are vested with the responsibility to act on their own cognition towards it. Certainly, if you're using illegal things in the purpose of business or trade, that's usually a criminal offense. So that doesn't involve too much, but you're right. Typically, you have to stand up for yourself and you have to involve somebody. It is going to cost money to go into court and get lawyers. On that, though, here's the benefit of PitchMark. What you do when you register as a PitchMark innovator is we maintain a list of a boutique list, a bespoke list, rather, if you will, of boutique IP lawyers, and we can help match creators up with them. These lawyers are in a position to give advice if you get ripped off. It will cost something, obviously. We don't insert ourselves in that discussion between the lawyers and the clients, but we do make those resources available. But yeah, typically, I'm sorry, civil litigation does actually cost money at the end of the day.
Is it true, though, that it's one thing to protect IP and another to enforce it? I mean, is that a sort of...
I'm sorry, say again.
Is it true? I mean, Ryan's first question was, we're commonly told that it's one thing to protect our IP and another thing to enforce it. I mean, is that true at all, just as a general statement?
Well, you protect your IP by enforcing it. So I think that it's one and the same, if I understand you correctly. I mean, you take these steps to do the registration, for example, of a design so that you get the benefit of these exclusive rights. If you don't register your design, you're not in a position to seek these injunctions or these legal damages that I mentioned before.
I hope that answers your question, Ryan. Cheryl,
Yes, thank you very much, Frank, for answering the question. Yes, and then we will have more time for more questions at the end of the presentation. Right now, we have Sue Ann, who is with DBC. She's on the EXCO of DBCS. So can we have Sue Ann to start her presentation?
Yeah, sure. Thanks for that, Cheryl. So just maybe a bit of background about myself. I've spent more than 10 years in a law firm practicing and specializing in IP, data and technology law. And then 2 years ago, I moved in-house to join Gojek as the head of legal and also to co-head the data tech and IP work stream within Gojek. So having joined the client side now and being part of a company that actually, there's a lot of creation of IP, there's a lot of looking at protecting your IP. I think if I didn't understand it before, I think it's all the more clear to me now how important designers, how important protection of IP is. So today I'm quite happy to share, I want to share a bit today about protecting your pitch. I think everyone here probably has a story to share, whether it's personal or whether it's from a friend or colleague, where they've gone to a pitch and frustratingly found from their work that their work has resurfaced elsewhere without their permission. And I think from the webinar that we've been having, a lot of it, I mean, I think it's great to have companies like PitchMark around where they're so focused on, and they're really providing an avenue to innovators and even companies receiving pitches on providing that assurance or that circle of trust among the creators and the receivers of these creations, and creating that kind of circle where assurance and guarantees can be given. So maybe I can just start. The first thing is going for a pitch, looking at a lot of it that's housekeeping at home. So looking at internal disclosures, and within the company, you often start the pitch and then you have a working group within the company. And I would say, just look at, even when you're working on the pitch, just look at disclosing your pitch on a need to know basis, even within the company. You can limit access to the documents, password protect the working documents. This also helps that in the event of any disclosures, it's easier to trace who had access to such documents, and also if there's any kind of need to take any action, it's easier to have the evidence or trace that as well. One other thing also is to look at employee confidentiality agreements. You will have a group of employees working possibly on a pitch, and if it's a particularly important pitch with a lot of creation in it or important type of work that's going to be encased in it, then you might want to look at either getting those particular employees to sign a confidentiality agreement, or to maybe highlight their obligations in their employment agreements, highlight their confidentiality agreements or non-compete agreement obligations in their agreements. The second thing I would say is to kind of look at who you're going to be pitching to, do a bit of due diligence on the companies that you're pitching to. I think with companies like PitchMark, of course, if there's a PitchMark guarantee, or if there's a logo there, of course that provides that assurance as well. A lot of times you look at industry reputation. You might hear from fellow colleagues, fellow friends, fellow industry insiders as to the reputation of a particular company, and often that actually counts for a lot in understanding where your pitch might end up. Some companies do set up in place an internal SOP, which is that they look at, okay, if we're going to pitch to this company, have we done our due diligence on them? Are they doing work for any other competitors? Have they signed an NDA? And I'll talk a little bit more about NDAs later on, what to look out for when you're presented with a template NDA. But if a company that you're pitching to is not really willing to sign your NDA, then you might want to really do a cost-benefit analysis to ask, why are they not signing the NDA, and probably at what stage is our work at this point of time. If there's a lot of detail that has gone into the pitch, you have mock-ups, you have specific details in the pitch, then you might want to really consider if they're not going to sign an NDA. If it's quite an early stage of development, and if the other party that you're speaking with is not willing to sign the NDA, then it's really, you just kind of have to make a judgment call whether you wish to go ahead or not. So that's the second thing I would say. Just be mindful who you're pitching to, and just have in mind, if they're not going to sign an NDA, then you have to kind of commercially decide if you do want to go ahead with the pitch, because there would be no legal recourse if the pitch is disclosed elsewhere. The third thing I would say is to ensure that there's a document trail. So ideas and concepts are not copyrightable. So as far as possible, do put all these ideas and concepts that you have into a written form as much as possible. Keep detailed notes and timestamps of when the work was created and when it was disclosed as well. And then conserve all working drafts that you have, so that in an event, if there's any dispute on ownership, or if there's any disclosure, unauthorized disclosure of the content that you have shared during your pitch, you do have this evidence or document trail that it was created by you, and that you are the owner of the copyright in it. So if we can go to the next slide. Yeah, so just the fourth thing. Again, I think Frank did a lot of the heavy lifting in providing really the context of what types of IP protection that there can be, and that you might want to look towards possibly obtaining for particularly important pitches or particularly important work that has been created. Sometimes it may be worth it to ask yourself whether you want to actually consider setting aside some budget, setting aside some time to go visit a lawyer to find out if the work that is contained in the pitch is actually registrable. For example, if what you're pitching for is an innovation or product packaging that is actually registrable as IP, either a patent or design, you may want to get legal advice on that as to how you may be able to protect that. It will come with a cost, but again, the cost-benefit analysis to see if it makes sense. And if it does, actually, statutory protection is always in a way the best way that you can fall back on to get any sort of legal recourse. There is also, although copyright protection is automatic upon creation in many of the jurisdictions, sometimes law firms can also kind of come up with, they can draft a statutory declaration for you where it's signed by a director of the company, for example, and this is actual evidence that this work has been created by you as of a certain date, and very useful in the event of any dispute over copyright ownership. So the fifth thing is NDAs. I think this is something that everyone is probably very familiar with here. And a lot of times, if you are pitching, you might be asked to sign a template NDA. And sometimes in the interest of getting the pitch across the line or efficacies of business, we do sign template NDAs. But I just want to highlight that not all, so there are a lot of template NDAs that actually might not be so favorable to you, and just some quick clauses that I think that would be helpful to point out that you might want to look out for if you are given an NDA and asked to sign it. So there are two types of NDAs. One might be a neutral NDA, where you are basically both sides, the receiver and the disclosure of information, both parties have to observe the obligations within the NDA. There's another type of NDA which is always a bit onerous on one party, and sometimes it depends on the bargaining power that you have. If you're pitching to a big organization, they will probably ask you to sign a one-way NDA, which is then basically you have to uphold the obligations within the NDA, but the other party might be a corporate, they're under no such obligations. So there's something that you might want to look out for. Of course, if you're going to be sharing information, it's always better for it to be neutral. But sometimes I do understand that some NDAs are not allowed to be changed. So then again, that's where you kind of have to make that judgment call. The other thing is to look at transfer of ownership or licensing clauses within the NDA. In some of the NDAs, it does provide that whatever is provided during the pitch is actually, the ownership actually is transferred to the client that you are pitching to, or it's a perpetual license, royalty-free license that will then be, that you are then providing to the client. Such clauses, again, of course, not very favorable, and something to look out for. I have seen also feedback clauses where, for example, and this kind of goes two ways as well, where the innovator actually has an NDA where actually says that whatever feedback that is received during the pitch actually belongs to, say, either the innovator or the client, and they can take that feedback and do whatever they want with it. So these are just, I mean, at the end of the day, it's up to you how you want to approach such clauses and whether you feel that it's something that you can give as part of wanting to do the pitch, but something that you should look out for. So quickly, length of NDA. Just make sure that usually I think it's better to have a limited time, a specific time, say a year, 2 years. If it's a technology disclosure, then often it's not going to go past 2 or 3 years, because by the time 3 years comes along, that technology will be obsolete and so will your NDA. So some NDAs, the length is extremely wide. It says forevermore. I mean, not in more legalistic language, or territories that they want to cover is the universe, for example, but such broad NDAs, you have to decide whether you're willing to provide that obligation. Scope as well, territories that it covers, business lines that it covers. Sometimes if you're going to sign an NDA with a client or with a company that has various business lines, you want to limit it to the particular, to a particular business line, so say like F&B, and not like, say, F&B, clothing, or whatever business line that they are in. So again, that's quite important to look out for. And then lastly, I think what I've said so far, all the above, is kind of a little bit of what it's something that it's not something that you can do before, or rather something that action might have to be taken if actually there's a disclosure, or you know, the breach has already been done. But there are some defensive strategies that we can look at as well. and I would actually include PitchMark as one of this, getting a PitchMark guarantee. But that kind of ties in with looking at the security of your pitch. So if you're going to be sending documents across, then limit access to the documents, restrict downloads, look at whether you're able to track whether the client has looked at the document, who they're giving access to. Any such kind of technologies that you can put in might be very useful, and also have a clear notice on your pitch work. For example, that all such content in this pitch is confidential, and where you can put copyright symbols, the C symbol, to show that this is your copyright, you own the copyright, and also ideally the year that it was created as well. So that's kind of in a nutshell the things that hopefully I've helped in pointing out or providing some insight into what you can do to protect your pitch. And hopefully this has been helpful. And if you have any questions, please feel free to ask and reach out as well.
Thank you, Sue-Ann, for that very detailed look from the designer's point of view, or from your organization's point of view, of what they should be doing. Frank has a comment about the NDA. You mentioned NDA is quite a key document to use in whatever form it takes. But Frank has a comment about that, and it's sort of how it connects to PitchMark.
Well, thanks, Agita. Yeah, no, I think Sue-Ann kind of concluded her remarks by saying it. Really, PitchMark was born from the idea that, yes, the NDA is, of course, the holy grail, and that's what anybody would ideally want in a perfect world. But I think the recognition was from some of the clients that we work with is that the NDA sometimes can be a hang-up. It can prevent people from getting over that hurdle. Or there might be various reasons why you don't want to introduce that level or formality, or it may just sort of quirk the deal, if you will. If you can get it, yeah, for sure. But as Sue-Ann mentioned, really PitchMark is kind of an idea of ours that this is an alternative, if you will. It served the same purpose of declaring or signifying to the recipient what's going on in an event that you can't, for whatever reason, or don't want to seek an NDA. So I think you're right. It's an additional resource. If you can get an NDA, great. But if you can't, that's what PitchMark's all about.
Thanks. And so the dying moments of the seminar, just wanted to point out, someone had asked for a recording of the webinar. We'll just have to make sure on whose website it's sitting. Do send us your emails. I mean, if you're all registered here, we might have those details anyway. We'll be in touch with details about the recording, if you can access that. Cheryl, you want to?
Yes, I will wrap up. Thank you so much to both our speakers, Sue-Ann and Frank, for taking the time and for their presentations. And thanks to everybody who signed up for the webinar and who has attended today. Thanks once again also to DBCS, for collaborating with us on this webinar. I think we've learned quite a lot from Frank and Sue-Ann on this webinar. And if you want any more details about DBCS, or you can visit their website, and also you can visit PitchMark's website to find out more about the kind of services that we provide.
It's the first time we're doing a webinar like this with a partner agency. So, we think this was quite successful. So we plan to do more of these. So watch this space. That's what I would say.
Thank you, Zhang.
So thank you, Sue-Ann, and IE and the DBCS team. And Frank for sharing all your wisdom about IP and its protection and enforcement. Thanks everyone for joining us on this Friday evening. Have a good weekend, and we'll be in touch.
Thank you. Thank you all.
Thank you.
Have a good weekend.
Chun Chuan, I think someone put their